conference, the same as being conducted via Zoom. The court is in receipt of a proposed consent judgment of divorce. Ma'am, you are Bethany Fisher, is that correct? You need to unmute yourself.
It's not muted. Can you hear me?
There. Okay, I can hear you now.
Okay, sorry.
Ms. Fisher, you've attempted to reach your husband Raymond and unsuccessful. It'll only take him 5 minutes. If he's working, he can step into a different office. He's going to his car to zoom in, but there are a number of issues we need to address. Number one, we need a child support order.
He doesn't work.
Okay, so do you want to reserve child support? And then which means that you didn't have to file a motion for child support later today. I'm trying to make things easy where we can get a child support recommendation today. We can attach the order to this judgment of divorce for the benefit of the children. Are you receiving any child support right now in another case?
For my oldest son.
Okay. It should be for all three. And secondly, he needs to confirm that he signed this judgment. And thirdly, there's an issue of a filing fee. Are you still receiving public assistance?
Yes.
Okay. Can you indicate your husband is not employed?
No, he's not.
Disabled?
No.
Okay. So what the court would do, they'll add a provision in judgment that he shall pay the $255 filing fee. Taxpayer should not have to pay the filing fee. If you're in public assistance, the court cannot order you to do that, but the court will order him to pay that. And I want him to be aware of that. And I'll give him a time frame if he needs 30 days in which to pay that. If he doesn't, then the court will issue a bench warrant for his arrest. So you cannot get divorced till you get him to appear. So if you text him, call him, we can be available later on today. If you want to get divorced, he should be here. He needs to confirm his signature on this judgment. And I need to need his presence here. So if he's not working, I mean, I don't know why he's unable to appear.
This is not anything new to me. He does not show up. He's not responsible, not reliable.
Okay. How does he support himself if he's not employed?
He lives with his parents.
How does he support himself if he's not employed?
He lives with his parents, so they support him.
All right. So Ms. Brower's here from the front of the court. Ms. Brower, do you have any suggestions? I suppose the judgment I can one option I could do is I could refer the issue of child support to the front of the court for formal investigation recommendation. Is that one option that would be acceptable to your office, Ms. Brower?
Yes, Your Honor.
Ms. Fisher, I guess the next question, did your husband Raymond sign his name to this judgment in your presence?
Which one?
The judgment of divorce. I mean, it's just a couple lines. It's not a legible signature.
Oh, yes, he did. Yes, he did. He scribbled it.
Okay, you signed it on February 15th. He signed it on February 16th.
Yes.
You can testify under oath that that's your husband's signature and he signed this and approved this judgment in your presence?
Yes, sir.
All right. The other question the court had before we proceed any further, there's the real property addendum that you are awarded the property on the real estate on Meadows Avenue in Flat Rock, but what about the mortgage debt? Is that in both names or only in your name?
It's in both names.
Okay. Well, typically he'll want you to refinance to get his name off the debt. This does not provide for any of that, and I want to make sure he's aware of that.
Correct.
Typically, if the mortgage is in both names and you're awarded the home, then you would have maybe say 6 months in which to refinance to get his name off the mortgage debt.
He knows that I am not able to refinance the home at this time.
Okay, so he knows that and he's not requiring that you do so?
So what we have looked up, that once the marriage, we have the divorce papers, we can send that to the mortgage company to ask them to remove his with a quit claim deed.
Okay. They may not do that.
Right. And he's aware of it.
They want as many people on the mortgage as possible.
He's aware of that. Okay.
Well, perhaps we can proceed then, as long as you can verify that, testify under oath that his signature's on this judgment. The court will, in fact, add a provision that he pays this filing fee of $255. add that he pay that on or before May 3rd. So you tell him that I've, since it's fair to appear, the court's ordering him to pay that. And the issue of child support, we can refer that to the front of the court for formal investigation recommendation with a commencement date of April 1st. And anything I add to this judgment, I will put my initials by that. Well, I guess we can proceed without his presence. This matter was scheduled for hearing at 9:30. It's now 9:53. Mr. Fisher has not appeared. He's not contacted this court. And Ms. Fisher, when you contacted him, was there just no response, or did he respond at all?
He did not respond at all. My children have actually been trying to contact him all week, and he won't respond.
Okay. As far as you know, he still resides on Michigan State Road 151 in Erie?
Correct.
All right. And he's not disabled. He just chooses not to work, and his parents support him. Is that correct?
He had hernia mesh surgery years back. He has not been diagnosed disabled, no, by any doctor. Every doctor that he's went to, they've said that they can't find anything wrong.
Okay.
So,
as far as you know, he's not in public assistance, correct?
Not that I'm aware of.
Okay. Does he see the children?
Yes, on his terms.
Okay. So when you next talk to him, you may want to let him know that he's got to pay this filing fee, and if he doesn't, the bench will reissue. All right. I guess we'll proceed. Ms. Fisher, can you raise your right hand to be sworn, please? Ms. Fisher, is it true that you filed a complaint for divorce with this court on or about December 11th, 2023?
Yes.
Is it further true that on the date you filed the complaint, you'd reside in the County Monroe at least 10 days, in the state of Michigan at least 6 months?
He resides in Monroe.
Is it true that you reside in the County of Monroe?
No.
Okay. Okay, so you live away, but okay, we can establish jurisdiction by your husband's residence. Is it true that your husband Raymond lived in the County of Monroe for at least 10 days, state of Michigan, at least 6 months prior to your filing this complaint on December 11th, 2020? I'm sorry. Yes, December 11th, 2023.
Yes.
Okay. You actually lived in Flat Rock, which is Wayne County, correct?
Correct.
Right. Is it true that you married Raymond Fisher on March 10th, 2014? You separated in November of 2021?
Correct.
Is it true there's been a breakdown of your marriage relationship to the extent that the objects of matrimony have been destroyed and there is no reasonable chance of reconciliation?
Yes.
Is it true there are 3 children born of the marriage?
Yes.
Are you currently pregnant?
No.
Is it true that you signed your name to this proposed judgment approving the terms and conditions contained therein?
Yes.
There seems to be a scratched signature dated February 16, 2024. Above the line says defendant signature. Did your husband Raymond Fisher sign this judgment in your presence?
Yes, he did.
Okay. Okay, this judgment, I'm going to go through this with you. It provides that the two of you shall share joint legal custody of your children. Over physical custody is awarded to you. Of course, the domicile of the children shall not be removed from the state of Michigan without approval of Mr. Fisher or the consent of the court. Parenting time, you've indicated parenting time will be made by mutual agreement of the parties. If in fact he wants somebody specific, he can always petition the court. Issue of child support. Since he's not appeared this morning, we don't know what his income is. The court will refer the issue of child support to the Monroe County front of the court for formal investigation recommendation with a commencement date of April 1st, 2024. So you receive, both of you will receive financial documentation from the front of the court. You need to complete that, send that back. They'll make a recommendation relative to child support.
Okay.
Now you indicate that there's a child support order for the oldest child.
He has a separate dad.
Okay.
My oldest son, I received child support from his dad.
Okay. That's Nico.
No. He's not on there. Isaac's not on there.
I'm sorry, I'm confused. There were 3 children born of your marriage with Mr.
Correct.
Fisher.
Correct. I do not
Okay, you
receive
had-
child support for any of the 3.
Okay, but is there a 4th child?
Yes.
Is that child a minor?
He's 13.
Okay.
But he is not Mr. Fisher's.
Oh, understood. Okay, we're talking about children born to you, Mr. Fisher. There are 3 children. You're not receiving any child support for those 3 children.
Correct.
All right, and that clarified. Judgment further provides that neither parties want spousal support. That's forever barred. You've already divided your personal property, so each keep the personal property occurring in your possession. Each will pay any debts in their own name. There are no joint debts, correct, other than the mortgage?
There might be credit cards. I don't think so.
We've not addressed that in the judgment. Ms. Fisher, you've got to, your judgment says each will pay any debts in their own name.
Yes. I mean, the cards might be in his name. I don't believe they're joint.
Okay, all right. So that'd be his responsibility. Each will keep their own automobile and pay any debt thereon. There are no pensions or retirement plans to be divided. And you're going to keep the name Fisher, correct?
Yes.
Again, the court will order the fine fee be paid by the defendant by May 3rd, 2024. The real estate property addendum indicates that the property known as 23123 Meadows Avenue, Flower Rock, Michigan, where you reside with the children, is awarded to you. And that Mr. Fisher shall sign a quitclaim deed within 30 days of entry of the judgment. You should be responsible for the mortgage. This does not require you to refinance the mortgage. So you can try to get his name off it, but most likely they will not, but it does not require you to refinance. And finally, there's a income tax addendum that awards you the right to claim all 3 children as dependents for tax purposes. Do you have any questions, Ms. Fisher? I'm sorry, I couldn't hear you.
No.
Well, when you talk to Mr. Fisher, you let him know that he failed to appear today. The judgment divorce was entered. Both of you will be mailed a copy of this judgment. You can let him know that he's got to pay a filing fee. He's got to borrow that from his parents, because if he doesn't pay it, the bench warrant would issue for his arrest. In any event, based on the testimony that's been presented this morning, as well as plain file this case, court finds that jurisdiction has been established by the defendant's residency. Court further finds that there has been a breakdown in the marriage relationship to the extent that the object of matrimony has been destroyed. There's no reasonable chance of reconciliation. Accordingly, it is ordered by this court that the marriage between the parties be and is hereby dissolved, and judgment shall enter, granting a divorce from the bonds of matrimony. Judgment has been signed. Good luck to Mr. Fisher. Copies will be mailed to you as well as to Mr. Fisher. You can zoom out.
Thank you.
Welcome. For the record, this matter is before the court for a pretrial conference. The same is being conducted via Zoom. Present is Attorney Maria Zagorski. Ms. Zagorski, I overheard that apparently, I don't know what happened, but you were not aware of the pretrial schedule for this morning. Is that correct?
I was not, Your Honor. There is no notice in my file. This was not in my calendar. I apologize. It'll probably show up next week, but I do not, I did not get notice of this pretrial. So I will proceed. As I was thinking, I knew that Ms. Spencer had filed an appearance. I was expecting a pretrial notice for a phone call, but I did not know about today.
All right, I think we can still proceed just to move the matter forward. The court will also know for the record, Attorney Alexis Spencer is present and Mr. Ryder is present with her. Ms. Spencer, Ms. Gorsuch, just for information, the court prefers have frank discussions, pretrial conference with counsel, without the parties. The parties' attendance is not necessary. As you know, the court simply schedules the matter, tries to determine what the issues are, and then schedules the matter for mediation. However, in this case, when the pretrial conference notice was mailed, Ms. Spencer had not filed an appearance. So whenever that happens, the 2 attorneys will confer and just let my office know they prefer a teleconference, and the court would with pleasure do a teleconference. But in this case, the notice went out before Ms. Spencer had filed her appearance. That's why it was set for a Zoom. Whenever there's an in-pro party, we always obviously have to do things by Zoom. I can't conduct it. I'm not going to do a teleconference with an in-pro per party. So just for information in the future, again, I was hoping that I would have heard from two of you and say, hey, let's do this phone conference, but I didn't hear from anyone. So sometimes people want to put an agreement on the record and leave it on the Zoom. But anyway, that's the reason why the matter was set for Zoom. Otherwise, if we knew Ms. Spencer was on board, we would have set it for a teleconference. But in any event, court knows this is a long-term marriage of 44 years. How long have the parties been separated? For a month and a year.
It was October 2nd of 2022.
That's what my client informs me as well, Your Honor.
Okay, so I just wanted to identify the issues. Do we have real estate that needs to be divided, personal property?
We do, and that is the primary issue. I had communicated with my client because of the complexities of the case that we schedule mediation with Mr. Godfrey.
Okay, do we have a date with Mr. Godfrey?
We do not.
That's
Okay,
what
hold
we're
on.
gonna ask for as well.
Do you agree with that, Ms. Spencer?
Yep,
Okay.
that's what we plan to propose as well.
Okay, I want to get this moving. I want to set another pretrial after mediation. And this is a deal case. I need to, Godfrey can be coming off. I need to take the proofs. So I'm going to put you on hold. I'm going to call Godfrey's office and get dates. I'll come back
And Your Honor, if you want
off.
to adjourn the pretrial prior to the mediation, I will have my client available to take proofs if you want that to happen.
We could do that, put it over a week or two, and then the two of you could reach out, and when we come back, you'd have a date with me, with Godfrey's schedule. That might be more efficient,
Absolutely.
right? Okay, but the issues are primarily is spousal support an issue?
It was not requested in the complaint or the answer.
There is a disparity in income. I would ask the court to reserve the issue.
Okay. Is there significant unsecured debt?
I don't believe so.
No.
Okay. Pension benefits?
Yes.
Okay. All right, I'm just generally marking that. We're not limiting the issues. I'm just trying to get some idea. Court will leave discovery open. Okay, so let's look for a continued pretrial conference. We can take the proofs, at least establish jurisdiction. There's been a breakdown. Court can reserve all issues. Let's try to do that to get later this month, perhaps. And if counsel could reach out to, if it's your intent to mediate with Godfrey, reach out and get some dates so that when you come back, you'll have an agreed upon date. And the court would, of course, schedule just continue pretrial immediately following that mediation.
That's fine. And I will initiate that contact with Ms. Burgandy and counsel included immediately.
Thank you. Thank you, Ms. Skorsky.
So Friday, April 19th at 8:30.
April 19th at 8:30. And this could be, it'll be a teleconference. Or no, I'm sorry, it's gonna be Zoom. We're gonna take the proofs. I'm sorry.
That's fine.
I could do that.
All right, so the court will notice of continued pretrial conference then on April 19th, 8:30 a.m. And Mr. Ryder is available. He should be present at that time.
Yes, sir.
Yes.
Okay, all right, thank you. All right, anything further than this morning, Ms. Spencer, Ms. Gorski?
No, thank you, Your Honor. Appreciate your patience.
Thank you for being available on short notice, Mr. Gorski. And again, in the future, just for your information, yes, if in fact you get a notice of pretrial and an attorney comes in late in the stage, just communicate if you want to do a teleconference. The court would prefer the teleconference pretrials. In any event, April 19th, 8:30, it will be a Zoom pretrial. We'll at least take the proofs. All right, thank you both.
Thank you.
Thank you.
Good rest of the day. Thank you. The record, Mr. Turner is appearing personally as ordered by this court last week for contempt proceedings. Mr. Turner, Ms. Hicks, correct, the court's recollection is there's 10 days hanging over Mr. Turner's head. Is that correct from a prior contempt finding?
Yes, that is correct, Your Honor.
All right, Mr. Turner, if the court recalls, the court suggested make a significant payment of perhaps $1,000 before today. That's why the court gave you a week to perhaps avoid or minimize any jail sentence. Did you make a payment since we were last before the court?
No, I wasn't able to,
All
sir.
right. Well, how much can you pay this morning?
I showed up with nothing.
All right. All right. Anything you want to say before the court imposes sentence, Mr. Turner?
No, I have nothing else to add.
Anything further from the front of the court, Ms. Hicks?
No, nothing additional, Your Honor.
Okay, Mr. Turner, it's ordered the court that you're to serve 10 days in Monroe County Jail. We can be released upon posting a $1,000 cash bond. So reach out to family and friends. If they can post a bond over the weekend, you can cut the 10 days short. Finally, we're going to be a date to appear before the court for review. Ms. Hicks, what date would you suggest?
Let me pull up the docket. May 28th at 10 a.m.
What month?
May 28th,
Okay, May 20th. I'm sorry, what time again?
10 a.m.
Right. Right, Mr. Turner, you're to appear before Ms. Hicks for review, May 28th, 2024, 10 a.m. You can appear via Zoom, and we just want to get you back on track. If you cannot afford this $245 a month, you get file a motion to reduce your support. You got to be proactive, Mr. Turner.
Okay.
You got to start making payments. You appear you're young, able-bodied. You got to address this.
Yes,
so
sir.
again, the sentence of court. Just have a seat. We're gonna have someone pick you up. You get over there for lunch. 10 days in jail, we can cut that short by paying you $1,000 cash. Let's go 100% toward your urges, not going to fines or court costs or anything. Let's go 100% toward your urges. Yeah, we can cut that short by paying you $1,000 cash. Let's go 100% toward your urges, not going to fines or court costs or anything. Let's go 100% toward your urges, which are about 19,000. You have pretty significant urges. If you don't start taking some real strong action on this, Mr. Turner, the state attorney general is going to authorize a criminal charge against you. It's called felony non-support, for which you can go to prison. So I'm imploring you to take care of this. Pay attention to this obligation. Do you have
Yes,
any
sir.
questions?
Where do I turn myself in at? I'm here at the courthouse now.
You can have a seat on the bench outside this this courtroom in the hallway. There's a wooden bench out there. Have a seat there,
Okay.
and they have someone be over in the next 10 minutes to pick you up and walk you across the bridge to the jail. And I'm just telling you, if you decide just to take off on your own, the court's going to add 30 days to this 10-day jail sentence. So the court would employ you just to cooperate and have a seat in that wooden bench outside the courtroom. Any questions?
No, sir.
You'll be mailed a copy of this notice to appear on May 28th. Your address is still, yeah. Okay. And again, make some phone calls. Maybe someone can put together $1,000 for you, and you can pay them back. So reach out to family and friends, okay?
Okay.
I was hoping that you come up with some payment today, Mr. Turner, but we've given you the opportunity. All right, anything further than this matter, Ms. X?
Nothing further, Your Honor. I'm preparing that order.
All right, thank you. All right, you can zoom out, Mr. Turner. Bruce, good afternoon.
Good afternoon.
Court is now in session. Rebecca Khalef versus Rolf Edward Hamad Khalef.
This court is handling this matter in the absence of Judge Lohmeyer. Present for this Zoom hearing this afternoon is Attorney Ronald Bruce, representing the plaintiff, Rebecca Khalef. Ms. Khalef is present. In addition, the defendant, Rafe Edward Khalef, also appears to be present. Good afternoon, everyone.
Good afternoon.
And Mr. Bruce, apparently the Mr. Pratt for the front of the court negotiated resolution this morning or this afternoon that you wish to place on the record. Is that correct?
Yes, Judge.
Okay. Mr. Khalef, good afternoon.
Good afternoon, Your Honor.
Listen carefully. The court's going to have Mr. Bruce state what he understands to be your agreement. After he does, I'm going to turn to you and ask you whether or not it's an accurate statement of your agreement. Okay?
Yes, sir.
And do you understand that if we once we confirm this agreement, you'll be bound by this agreement? Do you understand that?
Yes, Your Honor.
Mr. Khalef, good afternoon.
Good afternoon, Your Honor.
Listen carefully. The court's going to have Mr. Bruce state what he understands to be your agreement. After he does, I'm going to turn to you and ask you whether or not it's an accurate statement of your agreement. Okay?
Yes, sir.
And do you understand that if we once we confirm this agreement, you'll be bound by this agreement? Do you understand that?
Yes, Your Honor.
And lastly, do you understand, even though Mr. Bruce may prepare a judgment divorce, he technically represents your wife, Rebecca, and his loyalties lie with Rebecca. Do you understand that as well?
Correct, Your Honor.
Okay, right. Mr. Bruce, could you please say what you understand to be the parties' agreement?
Yes, Judge. I believe the parties have one minor child. Parties agree to joint legal, joint physical custody of the minor child. Parties are going to follow a 2-2-3 schedule, with the defendant father having Monday and Tuesday, mother Wednesday and Thursday. Parties will alternate the weekends. Mother agrees to drive the children to and from school from the defendant father's, during the defendant father's parenting time. Parties will follow the Monroe County Friend of the Court holiday schedule, absent any other agreement. Child support, defendant dad will pay mother $600 a month in support. Both parties agree to carry a health insurance on the minor child. Any medical expenses not covered will be split 50-50 between the parties. The plaintiff mother will be allowed to claim the child on her taxes every year. There'll be no spousal support to either party. It is barred as to both. There is no real estate owned by the parties. I believe the property is owned by my client's father. She will retain that property. Dad will vacate by June 30th, 2024. Parties will continue to pay maintain the status quo as to household bills until that date occurs. Personal property will be divided by agreement. Bank accounts, parties have one joint account. Defendant father will retain ownership of that account, and he will remove plaintiff mother. Each party will retain the vehicle in their own possession, hold the other harmless for any indebtedness or costs. Debt, each party will be responsible for whatever debts they have in their respective names and hold the other harmless. There are no retirement accounts to deal with. Attorney fees, each party will maintain their own attorney fees. And lastly, my client will have the option to resume her maiden name of Baron, Baron, at a later date if she so chooses. And I believe that's the entire agreement.
Thank you, Mr. Bruce. And I'm sorry if I missed this. Spousal support is not awarded, and that's forever barred as to both parties.
Correct.
All right, thank you. Mr. Khalef, did Mr. Bruce accurately state your agreement?
Yes, one portion of our agreement was left out, though.
Please go ahead.
It was if there was any international travel, the other spouse has to agree.
That is true, Judge.
Okay, so that language will be placed in the judgment. Is that correct, Mr. Bruce?
Yes, Judge.
Okay. And of course, presumably, if the other parent does not agree, either one of you could petition the court and ask the court to allow that. But yeah, at least if one of you objected, the other one would at least have, right to have their day in court to entertain their matter before the judge. You understand that, Mr. Khalef? So
Yes, I do, Your Honor.
You want to take your son and somewhere international, and your Rebecca refused. You could still petition the court, ask the court to permit that.
Okay.
And vice versa. All right. With that, Mr. Khalef, can you both please raise your right hand? Right, Mr. Bruce, if you want to begin with Miss Rebecca, please.
Miss Khalef, you had me file a complaint for divorce in this case, correct?
Yes,
And at that time, you lived in the state of Michigan for 180 days, County Monroe for 10 days, correct?
yes,
You have one minor child born between you and your husband, correct?
yes,
And you're not currently pregnant, correct?
yes, I'm not.
And would you state that there's been a breakdown of the marital relationship such that the objects of matrimony have been destroyed and there remains no reasonable likelihood that your marriage can be preserved?
Yeah.
And if the judge weren't to grant you a judgment of divorce, you wouldn't reconcile with your husband and get back together as husband and wife, correct?
Yes, I would not.
And you heard me place the terms of the judgment of divorce on the record, correct?
Yes,
You believe those are in your child's best interest and asking the court to adopt those, correct?
yes,
And if I believe you're agreeable to waive any statutory waiting period when there's a minor child, basically the court has to wait 6 months to enter a final judgment. You are fine with entering your divorce today, correct?
Correct.
And you believe it's in your child's best interest to finalize this divorce at this time, right?
Yes.
You understand you're not going to receive spousal support. It's forever barred. You can't come back at a later date and ask the judge for it, correct?
Correct.
And you don't have any questions for me or the court in regards to the terms of your judgment?
No, I don't.
Okay, Judge, I think that's everything.
Thank you, Mr. Bruce. And I'm sorry if I mispronounced your name. Is it pronounced Khalef?
Khalef, it's close enough.
Mr. Khalef. All right, Mr. Khalef, can you please state your name for the record and your current address?
My name is Rafe Edward, 162.
Thank you. Mr. Khalef, did you hear the testimony of your wife, Rebecca, this afternoon?
Absolutely.
Was her testimony true and accurate to the best of your knowledge?
Yes, Your Honor.
Do you have any questions for the court or any questions for Attorney Bruce?
No, sir.
Thank you. And you believe this settlement is fair and equitable and the provisions relative to custody and parenting time are in the best interest of your son?
I believe it's in the best interest of my son, correct?
Thank you. Mr. Bruce, do you have any questions of Mr. Khalef?
No, Judge, thank you.
So, Mr. Bruce, you'll prepare the judgment. How will you submit that to Mr. Khalef for his review? You're going to email it to him for his consent, or you submit that under the 7-day rule?
I think we've emailed him before. I'll probably send him a copy. He can sign it electronically if he wants.
All right. And Mr. Khalef, Mr. Bruce is going to prepare, is going to reduce all to writing in form of a proposed judgment. You need to ultimately approve that. So look for that when he emails that to you. And if you have any questions, call him so that you can obviously get this entered without delay. Otherwise, you can sign it electronically, or you can print it out and sign it and return to his office for entry with the court. Anything further, Mr. Bruce?
No, Judge.
Very well, the court, I'd like to thank and acknowledge Mr. Pratt for her assistance in helping facilitate a resolution. The court would applaud the two of you as parents. What if you can co-parent your son? He will thrive because you're both on the same page. And keep in mind, there will be challenges in the future as he gets older, more activities, and those can all be addressed through effective communication. So please, for his best interest, work together and communicate. And don't create drama for your son. That's the best you can do for him. Respect his mother, respect his father. Well, based upon the testimony that's been presented, as well as complaint filed, this case court finds that jurisdiction has been established and that there has been a breakdown of the marriage relationship to the extent that the average matrimony has been destroyed, and there appears to be no reasonable likelihood that the marriage can be preserved. Accordingly, upon receipt of the written judgment, the court will sign that judgment, and at that time, the court will order that the marriage between the parties be dissolved, and judgment shall enter granting a divorce from bonds of matrimony. Ms. Bruce, you can submit that to judgment to Judge Olmike for her signature. This case is assigned to her. In any event, that will conclude this matter. Everyone can zoom out. Have a good rest of the day. Thank you, Mr. Bruce.
Thank you. Have a good day.
Welcome.
Thank you.
Good luck, Mr. Khalef.
Court is now in session. Jesse Young versus Porsche Young.
For the record, this matter is before the court for pretrial conference. The same is being conducted via Zoom. It appears we have both parties present. Are you Jesse Young?
Yes, I am.
Thank you. And you're Porsche Young, ma'am?
Yes, I am.
Good afternoon. The two of you have conferred with Mr. Walker for the front of the court. Mr. Walker has indicated to the court that Ms. Young, you may wish to dismiss this divorce complaint. Is that correct?
Yes.
Yes.
Okay. You need to file a written dismissal with the court. It will not be dismissed until you find a written dismissal. So you can either go online, get the form, or if it's easier, come down to the courthouse and my staff can give you a dismissal and you can sign it.
Okay.
Mr. Young does not need to sign that. I'm sorry. Stand corrected. Jesse was one that filed this. Jesse, you have to file the dismissal. Portia does not have to sign anything. This is a dismissal without prejudice, which means if it doesn't work out, you can always refile. Mr. Young, when can you submit that dismissal to the court? Next week?
Monday.
Okay. All right. And again, you can go online. I'm not sure. Well, it looks like someone helped you prepare this divorce complaint.
Yes.
So perhaps that person could give you it's a form dismissal, or if it's easier, just come down to the courthouse to the 4th floor and come up to Judge Bronk's window and ask for a dismissal. Is that easier for you? Do you want us to prepare one for it before you and have it ready for you on Monday?
Yes. And I could come down and sign. Yes, please.
Okay. Come down to Brownlich Court. It's on the 4th floor of the courthouse, and we'll have it ready for you. And So it'll take a few minutes. So if you can do that on Monday, we'll look forward to that. And the court wishes you the best. Ms. Young, again, you do not have to sign anything. Just Mr. Young has to sign that dismissal. And
Okay.
then we'll mail you a copy of that, each of you. Now, the court will not be here on Monday, so it may take a week for the court to sign that. But if you can at least get it to come down and sign it next week, sometime, Mr. Young, that'd be great, so we can close out this file. All right.
Yes,
Do
Your
either of you
Honor,
have any-
will do.
Okay, do you have any questions, either one of you?
No.
No, Your Honor.
Okay, we made my day. It's always good to hear people reconciling, so thank you.
Thank you.
Good rest of the day, and good luck to both of you.
You too.
Thank you.
Thank you.
All right.